Diane McLeod from Alberta. Before we get to opening statements, our mandatory safety announcement. All virtual participants must use a headset and microphone approved by the Parliamentary Interpretation Service. If your headset is not an approved model, you will not receive interpretation. This is to ensure the safety of interpreters. And to avoid disruptive and hazardous audio feedback that could result in injury, we ask all in-person participants to keep their earpieces away from microphones. When your earpiece is not in use, please place it face down in the center of the designated sticker on the table. These measures are here to protect the health and safety of everyone, including our interpreters, and so we can conduct our business without interruption. Thank you for your cooperation. I believe that is all our housekeeping, so please proceed.
Hey, thank you. Bonjour tout le monde.
Hello, everyone. I would like to begin by thanking my colleagues from Quebec, BC, and Alberta for their collaboration on this milestone joint investigation. Our efforts demonstrate a shared commitment to protecting Canadians' fundamental right to privacy. New technologies such as artificial intelligence are fueled by the massive collection of data, including Canadians' personal information. While technological innovation can bring important economic, societal, and public interest advancements, the value of this innovation can be jeopardized if it is not built on a strong, secure foundation with the best interests of individuals at its core.
Investigation highlights the importance of prioritizing privacy in the development, deployment, and ongoing evolution of artificial intelligence so that Canadians are able to safely use and leverage the benefits of these technologies. Appropriate safeguards are the cornerstone of responsible innovation and are key to ensuring that Canadians can benefit from new technologies without giving up their fundamental right to privacy. Today, we are announcing the findings of our investigation examining OpenAI's collection, use, and disclosure of personal information to develop and operate its AI-powered chatbot, ChatGPT. Over the course of our investigation, we identified several concerns that led us to find that the way in which OpenAI had initially trained ChatGPT did not respect Canadian privacy laws. In particular, we found that OpenAI's collection and use of information to train its models was overly broad, resulting in the collection and use of sensitive personal information. Nous étions également préoccupés par des questions.
We were also concerned about issues related to consent and transparency, inaccuracies in the personal information provided in ChatGPT responses, the inability for individuals to access, correct, and delete their personal information, and a lack of accountability for the personal information under OpenAI's control. OpenAI launched ChatGPT without having fully addressed known privacy issues. This exposed Canadians to potential risks of harm, such as breaches and discrimination on the basis of information about them.
OpenAI took important steps to improve privacy protections and has also agreed to implement further measures to address my office's concerns. These measures will significantly limit the personal information that is used to train new ChatGPT models and will better protect the fundamental right to privacy of Canadians. They will also make Canadians more aware of the implications of using ChatGPT. I've concluded that the measures that have been and that will be implemented by OpenAI will address the concerns identified during the investigation with respect to PIPEDA, Canada's federal privacy law for the private sector. I've therefore found the complaint to be well-founded and conditionally resolved. Chacun de nos commissariats a mené une enquête sur la conformité.
Each of our offices investigated compliance with the specific legislation that it oversees, and therefore the conclusions vary due to differences in each of the laws. My office will keep monitoring to ensure that the company continues to limit the impact that its tools have on individuals' privacy.
Also further reinforces the need to modernize Canada's privacy laws for the digital age. As AI is increasingly being integrated into personal and professional applications, and while current laws apply to AI, Updated laws would help further support the safe deployment of new technologies to protect Canadians' fundamental right to privacy. I also expect that the findings of this investigation will inform and advance the privacy protective design of other AI-powered technologies. I would now like to invite my colleagues to further discuss our findings, et je donne la parole à Maître Naomi Ayotte.
I give the floor to Ms. Naomi Ayotte, Vice Chair to the Access to Information Commission of Quebec. Thank you, Commissioner Dufresne. Good morning, everyone. I would like to thank my colleagues, Commissioners Dufresne, Harvey, and McLeod, and their teams. The Commission had a privilege to work with their teams regarding this major investigation into a hot topic. The topic being collection and use of personal information in order to train a chatbot that is used by AI. With Bill 25, Quebec made a giant step forward in order to modernize its rules regarding protecting personal data and adapting to new technologies. That said, there are challenges regarding practices used by businesses. The increasing and rapid integration of AI in an ecosystem that is constantly evolving, where innovation and profits are sought out at any cost. Well, this comes to complexify the respect of rules and the exercise of rights regarding personal information. There are a multitude of sources of information on the web, and harvesting that data only increases our concerns regarding protecting privacy. New technologies can bring us further and faster. That said, if we allow them to feed off of our private data, we will be paying the price both collectively and individually. New technologies are only attractive if they don't put our rights in peril. Organizations need to adopt practices that respect privacy. Generative AI impacts all aspects of our lives, and so these technologies need to be created with an increased focus on fundamental rights. In Quebec, data is not public just because it is online. Furthermore, businesses can only collect personal information that is necessary. In the report that will be made public today, the Commission has noted that OpenAI did not implement sufficient measures in order to protect personal data of Quebecers. And it did not follow the Act respecting the protection of personal information in the private sector. Our Commission considers that OpenAI, in collecting personal information on the web, that it did not put in place reasonable measures in order to ensure the private information was respected and there was no consent given when required. It does not allow users of free ChatGPT to have the information necessary regarding the use of these chats, and these chats can include personal data in order to develop the algorithms. ChatGPT also didn't ensure that confidentiality parameters regarding the use of chatbots were ensuring the highest level of confidentiality. The Commission would like to note that OpenAI, during the investigation, implemented new measures regarding the collection of personal data, and it is limiting it and using a new model based on the recommendations. This should allow businesses to find innovative ways to protect personal data. This report highlights that tech companies cannot neglect protecting privacy on behalf of innovation. Protecting personal data needs to be at the heart of development in order for them to fully respect their responsibilities. The Commission intends to focus on the implementation of recommendations made in the report in order to ensure that the personal data of Quebecers is protected. I will now give the floor to my colleague from BC, Commissioner Michael Harvey.
President Dayot, and good morning, everyone. The report we're releasing today speaks to a fundamental disconnect between how one of the world's most popular and widely used artificial intelligence applications works and what our privacy law and the principles that underpin it demand. It highlights how far we need to go to create an environment where trustworthy innovation in AI can thrive, and it shows the extent of changes we need, both from innovators and from our laws, to make that happen. My office joined our federal and provincial counterparts to examine OpenAI's compliance with our respective privacy laws, in our case, BC's Personal Information Protection Act, or PIPA. We assessed OpenAI's collection, use, and disclosure of personal information with ChatGPT against the privacy protections our legislation provides the people of our province. What we found was that OpenAI can contravene PIPA in all but one of the 13 issues we investigated. To initially train ChatGPT, OpenAI scraped vast amounts of personal information from publicly accessible websites. This was widespread and indiscriminate: social media, discussion forums, blog posts, news outlets, and more, whether from a child or an adult. All of this publicly sourced information was obtained without any type of consent recognized under PIPA. In contrast, I am encouraged that OpenAI has taken positive steps to improve their practices, including retiring the initial ChatGPT models that we investigated, introducing filtering tools, changes to their data practices, and a commitment to compliance reporting. As a regulator, I must note, though, that the core issue remains unresolved. We're left at an impasse. On the one hand, AI applications have potentially transformative benefits. But in certain cases, such as the one before us, applications are developed without adequate privacy considerations. And on the other hand, those privacy laws were written for a different era and are strained to the breaking point. Both companies and the law have to change. In BC, I have written to our Minister of Citizen Services urging the government to act without delay to modernize our legislation to respond to today's challenges. This doesn't mean removing guardrails as this powerful technology races ahead. Instead, it means putting the onus on organizations to earn the trust of the people whose data they use. We need to start with consent, but where that is neither feasible nor appropriate, we need other legal authorizations in PIPA that come with strong guardrails, robust independent oversight, and the burden for compliance on the people profiting from the use of people's data. The goal is a BC where companies innovate and compete on how to empower people with control over their own innovation, not on how to deprive them of their autonomy over their data and extract value from it. Ultimately, the principal beneficiaries of the use of personal information must be the people to whom it belongs. We need to make sure that AI works for us, not the other way around. This is how we can lay the groundwork for trustworthy innovation. And this report makes clear just how much work we have ahead to make that a reality. Thank you.
Pass it to Diane McLeod, Commissioner from Alberta, who is joining us virtually.
Diane, you're on mute.
My apologies. I'll start again. First of all, thank you to my colleagues for their remarks. From the Alberta perspective, I want to note first that it is unfortunate and disappointing that technology companies have moved ahead so quickly with new developments and innovations without first ensuring that they are adhering to... Pardon?
You're on mute.
Not on mute.
Go ahead, please. You're fine right now. Yes.
Oh, okay. Sorry, I'll start again. Thank you to my colleagues for their remarks. From the Alberta perspective, I want to note first that it is unfortunate and disappointing that technology companies have moved ahead so quickly with new developments and innovations without first ensuring that they are adhering to privacy legislation. Our investigation found that OpenAI did not appear to pay adequate attention to privacy compliance in its development and deployment of ChatGPT, which is very troubling. The first ChatGPT model was launched in 2022, nearly 2 decades after privacy law in Canada applied to the private sector. The failure to ensure privacy is respected in ChatGPT development and deployment led to 12 findings of non-compliance with our respective privacy laws in Canada. This is unacceptable in a world where privacy rights are highly valued and fiercely guarded. In Canada, the right to privacy is a quasi-constitutional right. All technology companies designing and deploying AI should understand their duty to ensure privacy is protected as the law requires. That said, this investigation has shone a light on one of the biggest challenges to privacy protection in history. Technology has been moving so quickly, in particular in regard to AI. Personal information is being collected in ways that were not even contemplated when our privacy laws were written. As my colleagues have noted, the methods these companies use, scraping data from publicly accessible websites, could never be carried out in ways that would meet the consent requirements of Alberta's Personal Information Protection Act, or PIPA. My office has advocated for some time that changes be made to PIPA to allow for technology innovation but still provide privacy safeguards. Consent-based protections, for example, may no longer be feasible in an age when technology companies have easy access to so much information about individuals on the internet. Other options must be found. My office has been working to connect with the technology sector to ensure privacy is considered at all phases of technology development and deployment. We have also called on our government to regulate AI uses. The kind of regulation would require companies like OpenAI to evaluate the risks of this technology and to mitigate those risks before launch. Some may worry that we are trying to close the barn door after the horse has already bolted. There is a grain of truth to that. Technologies are moving so quickly that it is indeed challenging and perhaps even impossible to get ahead of it with legislation or regulation. However, there is always an opportunity to erect a fence or a corral around the barn. If you'll allow me to take the metaphor further, guardrails must be established to ensure technology companies are accountable for privacy protection. The incredible advancements in technology such as AI would have strained believability only a few years ago, yet these technologies are more ever present in our world. So it is reasonable to believe that we also have the expertise to find the necessary solutions, to develop new technologies in ways that safeguard privacy, and to include privacy in the design of new technologies. Perhaps the same type of innovative minds that develop these new technologies should work alongside privacy regulators to find creative ways to ensure privacy protection. My hope is that OpenAI has learned from this investigation and that other technology companies that are developing and deploying AI or other novel technologies also learn from this report that privacy must be a top priority and cannot be an afterthought. Thank you.
All right, we'll now turn to some questions. I see about 10 people on the list in the room. You can do the math on how much time each question and answer could take to get everyone in. We will start with Olivia Stefanovic, CBC.
Thank you so much. Since you launched your investigation, the Tumbler Ridge tragedy happened, and I'm just wondering if any of you have more concerns based on what you've seen in that case, and why should Canadians trust OpenAI based on what you've seen and the improvements that you say it's made?
Thank you for the question. So first of all, we have identified a number of shortcomings in terms of how OpenAI developed the initial models of ChatGPT. We're highlighting those in the report in terms of the scope, in terms of the consent, the accuracy, and so on. That said, in the course of the investigation, and because of the investigation, OpenAI collaborated, engaged with us, and put in place a number of measures to mitigate those risks. And this is why, from a federal perspective at least, I was able to find that they are ultimately resolved, those concerns that have been identified. So the engagement from my perspective has been good, and I would expect that this continues and take place in the context of the Tumbler Ridge situation, which really raises a separate issue of what should be the duty of organizations in terms of disclosing risks to authorities. And that's an important question. Canadians have to be protected. We need to find ways, and the government is working on this, and this may lead to some amendments. This may well be taken up by Parliament. At the end of the day, we need to be able to protect Canadians, do it in a way that protects privacy. And some of our key messages in this investigation go to that. We need to prioritize privacy at the outset. Privacy is not an obstacle to innovation, to the economy, and it's certainly not an obstacle to public safety. We need to work together to get that balancing right. I don't know if my colleagues, perhaps from DC, want to add.
Certainly. This investigation focused on primarily how ChatGPT trained and then used its models, or how OpenAI trained and used ChatGPT. The specific circumstances of Tumbler Ridge are, of course, a very specific use in that instance, and PIPA is engaged. So I guess from a BC regulator's perspective, the first thing I should say is that our first thoughts after the tragedy in Tumbler Ridge were for that community itself, for the people that were, and family and the community that were harmed. And that will remain foremost in our minds as we consider, as now with our legislative mandate, how we will consider how the Personal Information Protection Act has been engaged with this specific instance. And we're going to be trying to understand the best way that our office can add value. So we're monitoring these issues very carefully, and as you may know, there are many investigations ongoing to Tumbler Ridge. We're going to be considering how best we can add value, and we will communicate about that when it's appropriate.
Thank you. Not sure if Alberta or Quebec would have anything to add on that.
I will add a remark, and I would like to echo the comments of both Commissioner Dufresne and Commissioner Harvey with respect to the Tumbler Ridge incident. One of the things that I had mentioned in my opening remarks, and I believe Commissioner Harvey did as well, is there is a need to regulate artificial intelligence, its use, and so that the risks of harm can be assessed appropriately before these kinds of systems are launched. The question asked goes beyond our mandate to a certain extent. It often falls into the purview of privacy regulators because we're so connected to the kinds of issues that we're looking at from an artificial intelligence evaluation perspective. So we here in Alberta have called on our government to regulate artificial intelligence, and I think it's an important thing that we consider that at all levels of government to Canada so that we ensure adequate protections.
Thank you. As a follow-up, the Heritage Minister has said that the federal government has no choice but to act on social media use to protect young people. Do you agree with the minister, and do you think there should be a social media ban and a ban as well on AI chatbots based on your study?
Thank you for the question. Protecting children and protecting children's privacy has been one of my priorities and one of our collective priorities as a community of privacy regulators here and in fact around the world. So we have just issued a couple of days ago guidance from a federal perspective on age assurance and looking at the best interest of children. How can we make sure that children are protected online? And in some cases, it may mean that they should not have access to certain websites where there's a greater risk. In other cases, it will mean that we want to raise the protection for those websites. And that I think at the heart of these considerations should be what is the best interest of children. The first step need not necessarily be a ban. I think the first step should be, can we fix the underlying issue? Can we make it more privacy protective? Can we make it more safe for everyone, but particularly for children? In areas where we cannot, I think that there's a growing discussion on this, and I think the goal is to reach this balance where you're protecting children, but you're also giving them the ability to evolve in this increasingly digital world.
Laura Osman, The Logic.
Thanks for doing this today. You all mentioned to some degree the inadequacy of our current privacy laws. Can you just expand a little bit on how far short they are falling in this sort of digital age, how they're leaving Canadians vulnerable, and what specifically needs to be changed or updated to fix that?
Thank you for the question. So briefly, from a federal perspective, and this may be the area where there's a difference between federal and provincial aspects. The issue of consent as a basis, the obligations to obtain consent, creates a tension when you're talking about artificial intelligence development. In the federal law, I had more room to maneuver in the context of consent, so I was able to find ultimately that OpenAI could meet those requirements with greater transparency, with greater risk mitigation, with the evolving understanding and expectations of Canadians, but also with more work from OpenAI. So that said, I think that there is room for improvement. In European countries, for instance, you have legitimate interest as an alternative basis for consent, which makes it in many ways perhaps a better fit. This was present in the last version of proposed modernized law federally. So those are important opportunities to improve. Privacy impact assessments should be, in my view, mandatory, and I think that echoing the comments of my colleagues on this, and we need stronger enforcement tools. So from a federal standpoint, I think there is certainly room for improvement, but I will continue to apply the current laws as they stand, and in this case, I was able to make it work, but we could have and we should have stronger protections. I'll pass it on to my colleague from BC and Alberta and Quebec on their perspective.
Certainly. So I'll go first, but we're all in different situations, so I think explanation from all of us is important. In British Columbia, the law is somewhat different. So PIPA has been deemed substantially similar to PIPEDA, and they work together. However, on the matter of implicit versus implied consent, there is a very important difference in BC's PIPA. In that an organization to collect data cannot rely on implied consent if it's not collecting it from, if it's not collecting it, or if the organization didn't collect it itself. So implied consent under BC's PIPA can only work if the organization collected the information. Now, what we saw here was that OpenAI did not collect the information directly. It collected it from other parties that collected it, so it scraped it off of the internet, and it cannot rely on implied consent under our act for that. And so that's almost all of the information used to train those models was collected in that way. And so the consent model just does not work. And so this is what I referred to when I said that alternative models of legal authorization for collecting information must be obtained. No organization, public or private, in Canada can collect information without legal authorization. And so there needs to be a clear legal authorization. Now, that legal authorization, though, in saying that the consent model is not appropriate for, or may not be appropriate for training AI models, collecting this information at scale, we're not saying that we should just allow companies to just collect that information. Rather, that an alternative legal authorization must be created with the appropriate guardrails around it, and to ensure that that British Columbians, and I think all Canadians, can trust what's happening and trust that there's appropriate governance of that data. They can trust that there's effective oversight. So you asked for specific concerns, so things like algorithmic impact assessments, but also strengthening commissioners' authority. So I think any, under a law, the oversight, independent oversight should be backed with order-making power and the ability to levy penalties, as we've seen elsewhere around the world. So strengthened oversight. These are the things that would give people trust that the use of their information is for their benefit, and is not, that value isn't being extracted from their information for the value of others. So I'll stop there.
We'll give the floor to Alberta and then Quebec.
Oui, merci beaucoup.
Thank you. As colleagues mentioned, and rightly so, legislations differ from one province to the next. And so regarding conclusions in this report, there are certain differences. For Quebec, consent is very important in the other provinces, but there are other obligations in Quebec. We need consent, but there's also an obligation for information. And so certain things need to be disclosed by companies before data is collected. You'll be able to see that in the report, but OpenAI collects data in different ways, sometimes on the web, sometimes through third parties that they have contracts with. In all of those situations, there are different rules that can apply. So for Quebec, there were certain issues that were flagged, but the Commission concluded that the measures taken by OpenAI would conditionally resolve some of those issues. But for some, regarding consent, for example, there are other measures that will need to be implemented in order to comply with our legislation. So we made recommendations to that effect. And I would like to invite everyone to read the report, which includes a lot of relevant information on practices and rules that can be applied. As I said in my opening remarks, we will be following up with OpenAI and take necessary measures if needed. And to come back to what my colleague said, as the commissioner from Alberta said, there are issues with AI which will not be solved only through privacy legislation. There will need to be amendments to other legislation so that we go beyond the protection of personal information. This is to protect Canadians and Quebecers alike. It's very important to raise these issues because even if we're talking about personal information quite a lot, we can't solely focus on that. In Quebec, we moved forward with C25. It includes rules for protecting minors of 14 and under and parental consent, but not everything is covered. And we also need to remember that any additional measures, for example, verifying one's identity or banning or limiting access to AI tools, could be possible, and it is important to flag these concerns.
Thank you. Alberta's PIPA is substantially similar to PIPEDA as well. In fact, BC and Alberta's PIPA were drafted together and brought into force in 2004. The issues that Commissioner Harvey mentioned with regards to consent in Alberta's PIPA are essentially the same as those in British Columbia, which means that OpenAI, in the way that it did, could not ever get consent by scraping information off of internet sites, information about individuals off internet sites. So what this means is that in order for our laws to advance, in order to facilitate the advancement in innovation, including artificial intelligence, the laws will need to be reconsidered. And if consent is not the primary means of collecting information, there's exceptions to consent, then as Commissioner Harvey mentioned, there needs to be balance included in the legislation. So expanded oversight, expanded accountability, administrative monetary penalties, kinds of controls that would ensure that those adequate privacy protections remain in place, but also allowing innovation to occur in a responsible and reasonable way. And Commissioner Dufresne mentioned privacy impact assessments. That would be another way of evaluating technology before it goes to market. So all of these controls could be added in. In Alberta, our PIPA legislation is currently under review. We have made numerous recommendations about how to balance those requirements in PIPA to facilitate the innovation and ensure adequate controls. And our government is in the process of looking at those at the moment.
Thank you so much. As a follow-up, Commissioner McLeod, you mentioned this is a bit like trying to put the horse back in the barn. I understand that OpenAI is making a bunch of changes to try to improve things in the future. Is there any way to remedy the fact that these models have already been built on massive amounts of Canadians' private information that they didn't give consent to?
Well, I think it's important to consider what kind of information they have and the ability to decouple that information from a training model. So in this particular case, we determined that what they had collected was not in compliance with the legislation. One of the recommendations we made was around retention of the data included in those models. There was some assertions put forward by OpenAI that they are no longer using the very models that we were investigating in terms of the overcollection and non-compliance. And so I think it's important right now for me as a regulator to consider whether or not Albertans' personal information is something that we need to think about in terms of asking for deletion, considering they didn't have authority to collect that in the first place, if they're no longer using that information to train their models. So because we still have to assess those assertions, we can't determine at this point what steps we need to take, but we will continue to consider those steps.
And to say that under federal law, under PIPEDA, AI can be developed. So that's one of the differences where our conclusions, and those are set out in the report, where we've found federally that they were not initially done in a legally compliant way, and we're showing how they should have done that and how others should do that. And that means dealing with the reasonable expectations of Canadians, being very transparent, limiting the scope of what you're collecting and using, having these types of approach, using innovation to protect privacy, having retention mechanism, making it user-friendly for Canadians to know what information is there. If they don't want to be there, how can you opt out? So this shows in a way the powerful impact that an investigation like this one can have. But ideally, we wouldn't have to do this if privacy by design was applied. But really, my message is we can federally develop AI, but we need to be prioritizing privacy.
I might wish to clarify, though, that we investigated OpenAI's ChatGPT, and ChatGPT had a specific approach that was used. OpenAI used a specific approach to train ChatGPT where it scraped information off of basically the entire internet at that time, the entire open, what is sometimes called the open internet. But there's many other AI applications beyond. ChatGPT is an example of a large language model and an AI chatbot. But there's many AI applications, and we know that essentially all AI use cases use big data to train their models. That's a feature of machine learning, but they don't all scrape the entire internet. So it's important to say that our findings are about OpenAI and ChatGPT, and not necessarily every AI application that's being used. And there's many, many different types of AI applications used as innovation is progressing in Canada and around the world every day.
Yeah, I would just like to clarify that as well. Commissioner Harvey is correct. In fact, we have many applications of artificial intelligence operating in Alberta that we have reviewed from a privacy perspective. So artificial intelligence can and is being developed in Alberta and in compliance with our laws. And as Commissioner Harvey said, it was just this type of collecting of data that was problematic in this issue, in this instance.
Okay, again, I'd like to amplify that we have quite a few reporters here with a lot of questions, so some combination of speed or brevity would be helpful to get a lot of questions in here. En suivant, Monsieur Sabat, La Presse Canadienne.
Bonjour, Michel Sabat.
Monsieur Michel Sabat, Presse Canadienne. You have said that your investigation focused on strengthening privacy laws, and perhaps if you can give us an example, what would you like to see in a modernized legislation? Answer: I would like to see order-making power in new legislation, implementing monetary penalties and fines, and being able to carry out privacy assessments at the beginning of the process. There are other things as well, but I believe that we need to send a clear message that privacy and innovation go hand in hand. This can lead to more innovation and trust. Ms. Ayotte, I believe that the Quebec Commission can implement fines. And why haven't you? Do you not believe that it is important that there be consequences? Thank you for the question. You are correct. In Quebec, we do have a strengthened system. So we have those elements mentioned by Commissioner Dufresne. We have to assess privacy before any new project. We also have the option for administrative monetary penalties. That said, we are carrying out a common investigation or a joint investigation. And we have different legislations. So we do not have all the same powers or rules in place. And so given the issues that were flagged and the actions taken by the company and the choices made by the commissioners, we have decided to make recommendations instead. And so when we're giving recommendations, we haven't quite arrived to the stage of administrative monetary penalties. We also have a framework for these penalties that would explain its application. So we go step by step whenever possible. I'm not saying that there weren't any violations, but in the context of this joint investigation, we focused on recommendations. And so we will be following up with the company given our recommendations. Some things are considered to be conditionally resolved, but 2 things are still unresolved, and so we will be following up, and the Commission will use its oversight powers and will use administrative monetary penalties if necessary. We have these powers at our disposal. We are happy to have them, and we will exercise those rights when it is appropriate to do so.
With the National Post. Thanks for taking my question. For Mr. Dufresne, what is your understanding about why OpenAI didn't respect privacy laws and take into account what you characterize as known privacy issues in the first place? Did you ask the company that, and what was their response?
Well, in the report, we look at the issue of accountability, and we find that there was a lack of accountability, and we have some statements from leaders of the organization at the time saying we felt we had to move. We knew that there were others out there, and so we launched it without having done limited testing. So I can't speak for them, but there was a sense that they had to move quickly, but we found that problematic. We found that there were things that they could have done, and indeed that they have now done, that should have taken place before this was launched. And so that's the key message to organization is you can do this beforehand, you have to do this beforehand, and so rushing it to market will be problematic.
Just as a follow-up, some of the recommendations, it seems like there's some timestamps within 3 and 6 months, but millions of Canadians are going to be using ChatGPT likely today. So just to be clear, can Canadians today trust ChatGPT in terms of how it collects its data, handles their data?
Well, from a federal perspective, the answer is yes. I am finding this to be conditionally resolved, and the company has taken steps to limit the scope of the information that it is using to train the models, to be putting in place some retention mechanism to make it more user-friendly. They will be doing more things to make it clearer for Canadians. They will be communicating in a more user-friendly way, in a bilingual way. So we're going to be monitoring all of those things. We're going to be getting periodic reports. And if there are issues that arise where this is not being done, we will take the appropriate actions. But I'll pass it on to my colleagues for their perspective.
Sure. So I'll go first. What I will say is that it was a clear finding of our report that that ChatGPT is not compliant and cannot be compliant because of the requirement for implied consent. That said, we have at the BCO-IPC developed an infographic to provide advice to people in British Columbia about how best to how they can best use really any similar platform in a manner that is safe and privacy, or as safe as possible and privacy protective as possible under the circumstances. And I would say that we also are encouraged by many of the things that that we've seen ChatGPT do over the course of the investigation. And we're also encouraged by a number of the commitments that they have that they've committed to make. And with our partners, we will be monitoring their compliance with those commitments.
Thank you, merci. Boris Poul, Le Devoir.
Oui, bonjour.
Ms. Ayotte, this is Boris Proof from Le Devoir. My question is for you. In your first recommendation, I would like to say that I don't understand it. Is there not a checkbox to accept the conditions before using ChatGPT, and then you can read the 2,500 pages of text regarding the use of data? Is that not a reasonable measure, as you would call it, to receive consent to collect personal data? Thank you for the question. As I mentioned earlier, in the investigation into OpenAI practices, there are different models for collecting data. You're referring to a model focused on the user, and it's the user's use of ChatGPT. But we were focusing as well on training models, so there are no users in that case. So there is no checkbox there. And so we looked at what they used for data scraping or harvesting rather, and for consent. We won't get into the technical differences between the different elements, but people need to be advised. So yes, we can be given information, and yes, there can be checkboxes. They need to be presented at the right time, but the legislation includes what information needs to be given, how it needs to be done before information is collected, and it needs to be clear and simple. If we're talking about confidentiality, for example, if the information is difficult to find or the information is over many pages that people don't read, well, that leads to difficult situations and where it is difficult to be compliant. And so the Commission made recommendations in order to clarify the ways that information is given to ensure that when people are making decisions regarding their personal information, they are doing it with the knowledge of how that information is being used. For Commissioner Dufresne, now my next question. You talked about potential harm for Canadians and discrimination regarding one's personal information. Can you share what type of issues you are referring to? So we talked about data being accurate, so information is being collected and responses could be false or trendy or based on comments made on social media, based on disinformation. This is what we were referring to in saying that things needed to be correct. There needs to be more information to advise users that the information might not be entirely true. And OpenAI said that they would disclose the sources of this information more clearly. So we can validate where the information is coming from, and people can ask what information exists on their file, and they would be able to correct any wrong information. Thank you. Raphaël Perrault? Hello. I wanted to know, Mr. Dufresne, would you consider banning the use of AI for government employees? Is that one of your recommendations, given that they are violating privacy legislation? No, that is not one of our recommendations. ChatGPT models were developed in a way that did not follow the rules initially, but changes were made during the investigation regarding what is used to train AI and ways that consent can be obtained, focused on transparency. And so I believe that the complaint was founded, but that the issue has been at least partially resolved, and that OpenAI is doing what it can to comply. So that is my perspective federally, and so I would not recommend that federal public servants not use ChatGPT, and I do appreciate the commitments taken by OpenAI so far. So just to confirm, you would find it acceptable that people using government devices use OpenAI? And my second question is, who is your representative for OpenAI in Canada? They don't have an office here. Data centers for Canadian data are in the United States, if I remember correctly. In Europe, the data is being kept in Europe because they see that that could be a potential data breach. And so is this something that you are looking into? Regarding data leaving Canada, one of my recommendations in modernizing the legislation is to have a stricter regime regarding protecting Canadian data that is leaving the country. This is something that we're talking about more and more, and having data sovereignty. Regarding our representative, well, we speak to representatives from OpenAI because Canadian legislation applies to OpenAI because they have a potential impact on Canadians. They don't need to have an office in Canada and be local. Our rules apply to them. If you would allow me the opportunity to respond to the first part of your question. You'll be able to read the report, but we focused on personal information that could be used by the system. But regarding your question and the use of public servants, I need to specify that in a work context, there is confidential information. If you're working for government, you are dealing with potential protected information. So the Quebec legislation does protect information that needs to remain confidential in government. And when we use these tools to ask questions, we would be communicating information to those businesses. So there are conditions to the use. There are contracts and there are versions of these tools available to government. But we also need to remember that when we use chatbots, we are communicating information with them. So I wanted to specify that because it does pertain to access to information.
To ensure linguistic duality, one question for Marlo Glass et une question pour Julienne Lapointe, Radio-Canada.
Not sure if mine's. Oh, hello. My question is for Diane McLeod about the leak of Alberta's list of provincial voters. Elections Alberta and the RCMP have launched separate investigations. Is your office involved or will be investigating?
Thank you for the question. Yes, we are looking at this matter. We have been in touch with the Chief Electoral Office and the representatives there to determine what steps they are taking under the Elections Act. And we are currently assessing what our jurisdiction may be over the body that created the app and made the information available. So we should be releasing information later this week on that front.
Politicians and private citizens have been public about their concerns about their safety and their private information being public. What is your response to that?
Well, it's a very serious issue, and Albertans are very concerned. At our office, we're receiving numerous calls about the matter, and we certainly are following what's going on in the media, and we're paying close attention. And if we should have some information available tomorrow about the work our office is doing in this regard.
Thank you.
Bonjour, Juliane Lapointe de Radio-Canada.
Juliane Lapointe, Radio-Canada. Earlier, you mentioned penalties, but the message being shared to Canadians is that there needs to be, or that we pay fines when we're speeding, and if there are other issues, there are fines. But in not having fines here for somebody who violated our rules, are we not sharing a message that there are no consequences? And I ask you this question because we often hear talk about what the government needs to do, but there are people who know that their data is being used by these chatbots, but they think that it's fine because they're getting free therapy. So I would like for you to speak to the impacts of such decisions. I would like to reiterate that I do not have order-making powers or the ability to force administrative monetary penalties, and that is one of my recommendations. And you are completely right. Having these potential penalties will encourage companies to act more quickly and be more cautious. My goal is to have this ability, and it will lead to better decisions. And so this absolutely needs to be done. And for messages to Canadians, we have rules in place. We use them to the best of our ability. We are seeking important changes. But we could do more with modernized legislation. As a follow-up, is it not a risk? You say that there is legislation, but they're not being followed, and companies are just being thanked for making adjustments and course corrections. Is it not then risky to focus on a strategy on AI by government? I don't think that these things are mutually exclusive. I think that government can promote an industry while strengthening legislation, privacy legislation. I think that if we strengthen privacy, if we have stronger sanctions and penalties, we increase trust for Canadians and for users. This is good for the economy, and it is also good for people. We're talking about a fundamental right, as my colleagues mentioned. And so I completely agree. We need to strengthen our laws. That should be a priority.
Save so much time, we have time for one last question. Maria Collins, Wire Report.
Thank you. In your guidelines published earlier this week on privacy protective age assurance, you said developers should ensure deletion of any personal information that they gathered after processing an age result. In terms of today's findings, can you talk a little bit more about how OpenAI is governing the retention and deletion of personal information to protect against a potential breach?
Well, thank you for the question. And so we pushed to have, they didn't have a clear retention schedule at the outset, and now they do as a result of this investigation. So it's going to include new technological approaches. They're going to be providing us with some updates on this, and they're going to be discontinuing some use of information over time when it's no longer necessary. And so we're going to be monitoring this, but this is an example of a clear gap that we identified in this investigation and that led to those recommendations. Maybe ask if my colleague Diane McLeod has more to add on that point.
Oh, thank you, Philippe. Yes, I think you covered it nicely. It is a requirement in PIPA that organizations have retention and destruction policies and procedures. And as Commissioner Dufresne just indicated, this was something that our report identified and our recommendations were made regarding it. And OpenAI has indicated that they will comply with that.
All right. Thank you very much for everyone's time today. Merci beaucoup. Miigwech. See you all again soon.